Welcome back, and our next session is determining jurisdiction in cross-border cases. The session will shed further light on different legal traditions and recent case law developments in determining jurisdiction in IP cases, globalization and cross-border IP cases, conflict of laws in IP cases, and challenges in determining jurisdiction. We have the speakers already with us, and our moderator, Mr. Christian Wichert, Deputy Director General of FIPO. Thank you.
Thank you. Welcome, ladies and gentlemen. Welcome to this panel. This panel actually is one of the two most challenging panels of the whole Global Congress. Not so much, apparently, So one of the two most challenging panels of the whole Global Congress, not so much because of the subject, jurisdiction, but I think because of the timing, just after lunch. I think while you may have enjoyed the lunch, I'm sure, and I'm sure you've also enjoyed all the networking and the discussions, I'm also sure that this panel and this discussion will be worth your while, because the topic is actually quite technical, but also very important. We will look at the jurisdictional infrastructure, the tools, the jurisdictional tools that allow right owners to act against counterfeiting and piracy. How can you identify the competent court that can provide judicial assistance against counterfeiting and piracy? And this is particularly difficult if you look at cases that involve more than one country. And, ladies and gentlemen, this is highly likely when we look at counterfeiting and piracy, because counterfeiters and pirates think global, they act globally, the whole value chain is likely to be global. The problem then is that the administration of justice is a very national concern. There are simply no international intellectual property courts. Well, just to pick a quick example, imagine your trademark is infringed by counterfeit goods. Products may be produced in one country, let's call it A, from components that come from yet another country, let's call it B. They're shipped through a number of countries, let's call them C. They are put on the market in yet other countries, D, and you're based in another country, E. Where do you sue? Where you are based, country E. Where the infringer is based, country A. Where the goods are produced, A or B, where they are within one of the countries through which they have been shipped, C, or where they have been put on the market, D. All of the above? Well, and which court can help you stop the production and the distribution quickly if you need that? How can you get hold of the producer? If you've been successful in one country, say the country where the goods are available on the market, country D, can you enforce this judgment against the infringer in his home country? A. And what about criminal procedures? Counterfeiting, piracy tend to be criminal offenses in most countries. So these problems get even more difficult when you add digitization and the internet, because then very often commercial relationships, including illegal ones, lose any territorial link and just become almost ubiquitous. As just that to show you that international aspects of jurisdiction quickly get very complicated. They get complex, but they are, I think that example has also shown that, extremely important. Because they are so complicated, I'm very excited and delighted that we have a panel full of eminent experts in the field who will be able to shed some light on these tricky issues. I will introduce them now quickly in alphabetical order. Professor Oundin, next to me here, is a very prominent intellectual property specialist, a lawyer from South Africa who has been practicing as a partner with the IP law firm Spoor & Fisher in South Africa. He's specializing in trademarks and copyright, and especially litigation. And he's also worked as a government advisor. He served on the South African government's advisory board for intellectual property law for 20 years, and he's chaired the drafting committee on the Counterfeit Goods Act. He's also, since 2011 now, professor at Stellenbosch University, chair of the, basically heading the intellectual property chair. Professor Rochelle Dreyfus, now at the other end of the podium. She's professor at the New York University School of Law. She also specializes in intellectual property law, and in particular patents law, but also in civil procedure. She is the author of many important works on intellectual property law, and in addition to quite a number of impressive advisory positions, both in academia and government, she is a member of the American Law Institute and was a co-reporter for quite an important project, a co-reporter for its project on intellectual property, on the principles governing jurisdiction, choice of law, and judgments in transnational disputes, the ALI project, which is really quite on the mark for this panel discussion. His Honor, Michael Feisch. He practiced as a barrister in the field of intellectual property in England and Ireland, as well as in a number of Commonwealth countries, including Australia, India, and Pakistan. He was appointed a judge in 1999, and from 2001 had responsibility for the Patents County Court in England and Wales, and established that court as quite an efficient and effective and prominent court, certainly in England. From 2005, he's also been chairman of the UK Copyright Tribunal. Now he's fellow of the Institute of IP Law at the University of Oxford, and also a visiting professor at the Indian Institute of IP Law in New Delhi. Professor Annette Kur, at the other end of the podium, is senior research fellow at the Max Planck Institute for Intellectual Property and Competition Law in Munich, and professor also at the University of Stockholm, as well as visiting professor, has been visiting professor at quite a number of other universities. She specializes in the law of trademarks, designs, especially the international aspects, and also on procedural law. She has been a founding member of the European Max Planck Group on conflict of laws and intellectual property, which prepared principles on conflict of laws and intellectual property. And these principles also cover international jurisdiction as well as recognition and enforcement of foreign judgments in intellectual property. So again, quite an important and topical project. Mr. He Fang, he's an intellectual property lawyer based in China and an experienced intellectual property litigator. He actually heads the dispute resolution team in the China office of the international intellectual property law firm Rose. And he specializes in litigation, especially concerning trademarks and copyright. He has law degrees from China and England, and is also a mediator. And then, just because of the alphabet, last but certainly not least, Judge Hazel, Zhang. She's a high-ranking specialized intellectual property judge here from Istanbul. She is judge at the first civil tribunal, I think, that was established to deal specifically with intellectual property matters. And she's been sitting as judge since 2003. She's held several judicial positions, including one at the Turkish Cour de Cassation. She was educated both at the University of Ankara and the Centre d'études internationales de la propriété industrielle in Strasbourg in France. Ladies and gentlemen, just quickly on the format of this discussion, we will now have very brief introductory presentations by each of the panelists, and then we'll start a discussion first among the panelists, and then also increasingly involving you, the audience. We hope to make that panel as lively and interactive as possible, so also look to you to participate both with comments, questions, and also share your experiences on jurisdictional aspects of counterfeiting and piracy. But now I would like to go straight into the matter of our discussion, and would invite Judge Feisch to give us his perspective on the topic. Judge Feisch, you have the floor.
Thank you very much. Thank you very much. Can you hear me all? Good afternoon, and first of all, thanks for the invitation to be here. It is a great pleasure to be in Istanbul and in Turkey, and I thank the Minister of Customs and Trade for putting on this wonderful conference. It's a particular pleasure for me to come to Turkey because my wife's great-uncle was British ambassador here in the 1930s. I knew him, and he frequently spoke of the founder of your great republic as a personal friend, and he put it to me once as one of the few great leaders that he had great respect for. So it's always a great pleasure to come to Turkey for me. Now, I want to make some general observations. I've been listening to the talks for the last 2 or 3 days, or 2 days at any rate, and I've come to the conclusion that I must put in something for the judges. Now, there are 2 of us here who are judges. There's me from the common law background, and later you'll hear from my colleague, Judge Gangu from Istanbul, who is of the civil law background. I think that you must appreciate that there is a distinction here. Now, second general point, remember, if IP cases fight, they come to us. We judges decide the disputes, we act neutrally, and we hope to administer justice. Now, of course, many don't fight because of cost and because of practicalities. We have an expression in English, pick the lower fruit first. In other words, the little men get caught, and the big men very often do not get caught. And when they do, they hire IP lawyers who fight every point. And some of the points in IP law, as some of you know, are very difficult indeed. So, quite often you will find that the bad men, the people who really should be punished, get off scot-free. Remember this also, from the judge's perspective, about 50% of the cases that come to us are won not by the rights holder, but by the defendant. Now, why? Remember, copying as such is not illegal. Indeed, most of our systems actually encourage competition. There are whole fields in EU law which actively promote competition, in American law, in Australian law. What is wrong is infringing subsisting valid rights of IP. Remember, infringing, that's the first test. Subsisting, that is, they've got to exist and be owned by the claimant, and they've got to be valid. These are all quite complicated areas of law. Now, the moral is always make sure you obtain competent specialist advice in acquiring, enforcing, and defending IP rights. I mention all this simply because from time to time, it seems to me that people have been talking about counterfeiters, pirates, smugglers, and so on. I'm afraid that is not the way IP lawyers look at the matter. We have to look at the IP right. Is there infringement? Is the right subsisting? Well, is the right subsisting? Is there infringement? And is it valid? Cross-border issues next. Cross-border issues have taken some steps forward in the EU and the EEC in recent years. And I can't really speak of the rest of the world because I'm not competent to do so, and no doubt my colleagues will have something to say about it. But in Europe, we have the Brussels Convention, the Brussels Regulation. It's all very complicated. But the upshot, which you should know about, is basically this, that as a result of 2 important cases, one called Solvay, S-O-L-V-A-Y, and the other in England called Actavis, A-C-T-A-V-I-S, is this, that though it may be difficult to enforce, rather to establish and then enforce cross-border rights, it is not by any means impossible and is becoming a little more easy, particularly in interlocutory cases. But tricky questions remain. Finally, remember, surprise is much more important than running cases that will last for years. And in that respect, the United Kingdom and Ireland, for which I can speak, and incidentally, those dependent territories of the United Kingdom, which are often used by counterfeiters, the so-called tax havens, I speak of the Channel Islands, British Virgin Islands, that sort of place, those places work according to UK law and Irish law, where we do have remedies to surprise the counterfeiter. There are Anton Pillar orders, search and seize orders, money sequestering and freezing orders called Maravas, and there are also other orders regarding deep disclosure, what we call Norwich Pharmacal, and also we can sue directors, and we allow for joint tortfeasance. So even though you may have to go to other jurisdictions to get satisfaction, you have the element of surprise and certainty of law. So don't rule out effective and surprise action in these jurisdictions. It's perhaps a little like London and Dublin in the tropics. Right, that's my 5 minutes.
Thank you, Judge Weiss. I'm sure we will come back to I'm sure we will come back to some of the points you raised. Thank you for giving us your perspective as a judge from the UK. Now we hear from Judge Hazel Gangu. Judge Gangu, you have the floor.
Merhaba sayın katılımcılar. Burada sizlerle olmaktan onur duyuyorum. Türk mahkemelerinin milletler arası yetkisi ve kanunlar itirafına ilişkin düzenlemeler Avrupa Birliği'nin Brüksel, Lugano sözleşmeleri ile Roma 1 ve Roma 2 regülasyonlarına paralel düzenlemelerle öngörülmüştür. Sadece iki önemli noktada farklılık var. Onun dışında hükümler tamamen paralel. Bizde sınır ötesi uyuşmazlıklar ağırlıklı olarak yurt dışında, özellikle de Amerika Birleşik Devletleri'nde tescil edilen alan adlarıyla Türkiye'deki marka ve ticaret ünvanları arasında söz konusu olmaktadır. Burada marka ve ticaret ünvanıyla alan adı arasında benzerlik varsa ve Türkiye'de erişim mümkünse ve ayrıca alan adının ilgili olduğu site Türkiye'yi hedef alıyorsa, yani Türkiye pazarına düşünerek organize olmuşsa, burada siteye erişimin önlenmesine, fakat alan adının ülkesel olması, Türk marka haklarının ülkesel olması nedeniyle alan adına ilişkin iptal taleplerinin de reddine karar veriyoruz. Biz iptal davasını reddetmekle beraber WIPO Tahkim Kurulu'nun AYKE'nin prensip kararlarına göre vermiş olduğu bir tahkim kararına yapılan itirazı kabul ederek davanın esası hakkında inceleme yaparak karara yapılan itirazı reddettik. Dolayısıyla da bu itirazlar yönünde mahkememizin yetkili olduğuna karar verdik. Ancak bu kararın iç hukukta bu konuda mahkemelerimizin yetkisi yoktu yasaya göre. Çünkü yasalara göre tahkim kararına karşı sadece tenfiz mümkün. Zaten biliyorsunuz 1958 tarihli New York Tahkim Anlaşması'nda da sadece yabancı tahkim kararlarının tenfizi söz konusu olabiliyor. Ancak biz bunu Medeni Kanun'un 2. maddesindeki hakimin yasanın hakime verdiği takdir yetkisini kullanarak boşluk doldurmak suretiyle kabul ettik ve bu yol bu şekilde verilen kararı Yargıtay da onadığı için içtihatla bu yol açılmış oldu. Ve bundan sonra artık bu şekilde gelecek olan itirazlarda mahkememiz yetkili olacaktır. Yalnız internet üzerinde işlenen suçlar tabii ki alan adlarından ibaret değil. Burada aracı kurumların özellikle servis sağlayıcı ve yer sağlayıcıların, yani internette pazar yeri işleten işleticilerin de sorumluluğu söz konusu olabiliyor. Bunlarla ilgili de 2 dava söz konusu oldu. Bunlardan birisi Ibay'ın da Türkiye ortağı olan Gitti Gidiyor firmasıyla bir Fransız firması arasında söz konusu oldu. Fransız firması Lancôme'un taklit ürünlerinin bu sitede satıldığı iddiasıyla bir dava açıldı. Bu davada Lancôme bu ürünlerin taklit olduğunun davalı tarafından, yani site işleticisi tarafından taklit olduğunun bilinmediğine dair bir iddiası yok, bilindiğine dair bir iddiası yoktu. Doğrudan doğruya sitedeki teknik hizmetlerinden dolayı, yani stoklama ve afişe etme fiillerinden dolayı sorumluluğun marka haklarına tecavüz ettiğini iddia etmişti. Aynı zamanda Fransız şirketi Fransa'daki bazı kararları da iddiasına dayanak olarak sundu. Yalnız ben o arada, o tarihte Türkiye'de bu konuda yasal düzenleme yoktu, boşluk vardı. Ben Avrupa Birliği'nin elektronik ticarete ilişkin direktifinin derogasyonu düzenleyen 14. maddesi ile TRIPS'in fikri mülkiyet ile rekabetin düzenli dengelenmesine ilişkin giriş gerekçesiyle diğer buna benzer 40. ve 6. maddelerinden hareketle bunun sadece otomatik olarak verdiği teknik hizmetten dolayı sorumlu olmayacağına, bunun marka haklarına tecavüz oluşturmayacağına karar verdim. Bu kararı 2009 tarihinde vermiştim. Yani Avrupa Adalet Divanı'nın Google ve eBay kararlarını vermesinden çok önce. Bu kararda davacının açmış olduğu maddi manevi tazminat davasıyla tecavüz davasının reddine, sitede bulunan o ürünün, taklit ürünün ürüne erişimin engellenmesine, onun siteden çıkarılmasına, davanın açılmasına davalı şirket sebep olmadığından, yani Fransız şirketi haksız olduğundan yargılama giderlerinin de Fransız şirketine yükletilmesine karar verdim. Buradaki uygulama, bu vardığım çözüm IBAY'ın, Avrupa Adalet Divanı'nın daha sonra IBAY ve Google'a verdiği kararla yani kopya düzeyinde benzer. Tabii bunun böyle olmasının nedeni de bizim kendi mevzuatımızın da Avrupa Birliği'nin marka hukukuyla aynı olması, oradan alındığı için. Bu karara karşı Fransız firması temize başvurusu yaptı ve Yargıtay bunu bozdu. Bu gerekçesinde sadece teknik hizmet vermesinin, yani fiile katılmış olması söz konusu olmadan da sorumlu olabileceğine, bu teknik hizmeti vermekle, yani o ürünü, o bilgiyi orada stoklayıp teşhir etmekle fiile katılmış olduğunu kabul etti, iştirak etmiş olduğunu kabul etti ve bu karara karşı ben daha önce verdiğim gerekçeyle direnme kararı verdim. Karar şu anda genel kurulda. Bizde direnme kararı verilen durumlarda Yargıtay Genel Kurulu'ndan seçilen 40 üye dair bu kararı görüşmekte. Bu kararın sonucuna bağlı olarak Türkiye'de bu internet ortamındaki bu tür servis sağlayıcı ve yer sağlayıcı firmaların sorumluluğu netleşmiş olacak. Yani şu anda bizim yerel mahkemeyle Yargıtay aynı görüşte değil. Yine bununla bağlantılı olarak Google'la karşı bir dava açıldı. Amerikan firması, biliyorsunuz. Google'un da AdWords reklamlar nedeniyle marka hakkını ihlal ettiği iddia edildi. Burada da ben yine diğer önceki davaya benzer gerekçeyle burada Google'ın sadece otomatik olarak servis almaktan ibaret, yani o bilgiyi oraya yansıtmaktan ibaret fiiliyle marka haklarına tecavüz etmediğini, bu tecavüzün asıl reklamı veren kişiye ait olduğunu kabul ederek davayı reddettim. Bunu bu yakınlarda verdim. Henüz Yargıtay'a gitmedi. Yani bizim buradaki uygulamalarımız genel olarak böyle. Burada bir şeyde dikkat çekmek istiyorum hakim olarak. Burada Amerika Birleşik Devletleri'nde tescil edilen alan adları, özellikle top level alan adlarına ilişkin uyuşmazlıklar son 2 yılda çok müthiş bir şekilde arttı. Öyle ki artık kendi açılan tedbir ve tespitler yüzünden normal davalarımıza bakamaz bir duruma geldik. Kanaatimce burada bu tesciller sırasında tescil başvurusunda bulunan kişiden o tescil ettirmek istediği ibarenin o ülkenin yasalarına göre değil de o ülkedeki ticaret odalarından veya ticaret sicillerinden yahut da ofislerden ibarenin serbest olduğuna veya kendisi adına tescilli olduğuna dair bir belge, resmi bir belge istenirse büyük ihtimalle bu uyuşmazlıklar %90 oranında azalacaktır. Çünkü bunlar genelde zaten WIPO'nun tahkim kurulunun sonuçlarından da anlaşıldığı üzere büyük oranda açılan tahkim davalarında transfer kararı verilmektedir. Bu da zaten bunların kötü niyetle tescil edildiğini göstermektedir. Bu şekilde bir çözüm getirilirse yalnız Türkiye'de değil sanıyorum bütün dünyada marka hakları ve ticaret ünvanlarına ilişkin haklar daha etkin korunmuş olabilir. Bu aslında zor bir çözüm değil. Yani 2 belge istenmesinden ibaret. Teşekkür ederim.
Thank you. Thank you, Judge Zhang, for giving us 2 case examples, or 3 rather, case examples relating to the digital environment. The first case relating to a decision rendered by you in which you, in a way, decided to recognize and then also to enforce a decision rendered by a panel, a domain name panel established under the Uniform Domain Name Dispute Resolution Policy. Another case between Lancôme and eBay where you actually, before the European Court of Justice, already applied the safe haven provision of the European e-commerce directive, and which is currently still, I understand, under consideration with the Turkish Supreme Court. Thank you for that. I'm sure these cases from the digital environment will still also play some role in our discussion later. I would now like to move in a way to the legal practitioners we have on the panel and would invite now Mr. Fang He to give us.
Thank you, Christian. Thank you. I'm really feel honored to be speak here and share my views and private practitioner on forum shopping. From the discussion from the 2 judges, we already realized how complexity of the national law might be on the matter of IP. I want to start my quick discussion from 2 common misunderstandings in the decision of choosing a proper forum or venue for IP litigation worldwide basis, and I will make a slightly breakdown into the China situation. The first common misunderstanding, of course, I have to understand it's human nature is people are more likely to trust his own jurisdiction or a familiar jurisdiction. Like a common law trade lawyer is more likely to trust the Hong Kong system or the US system rather than the China system or Vietnam system. But the issue is the situation becomes much more complicated when enforcing IP rights worldwide. In particular, in the scenarios, the most multimedia, multinational corporation will have worldwide existence. How to balance the cost and the efficiency as well as the impact on the infringement chain or counterfeit chain will be a key element to decide on a proper forum. I'll give you an example. Let's look at the Hong Kong-China situation. Yes, the Hong Kong system is extremely efficient when talking about a custom seizure. And it's also a predictable jurisdiction according to a lot of barrister or solicitor experience in other countries. But the Hong Kong jurisdiction is too much expensive if the case is going to trial. And our client, the plaintiff or the defendant, probably have to pay a similar barrister fee as to the UK, in the UK or the United States, to reach an infringement verdict. And in most situations in Hong Kong, the case is suspended or stopped at the stage of interlocutory injunction. Because it's too expensive, too costly, and Hong Kong is tiny compared to the China. The scope of the interlocutory injunction will be very limited. But a lot of brand owners began to look beyond this jurisdiction and look at China, because China is the source of the manufacture. Sometimes the brand owner have to make an industry analysis to identify the driving forces of the counterfeits. We see a lot of situations that the ordering party was either from Africa or Middle East and or United States or a part of Europe, and the manufacturing happened in China, and infringing products exported by Hong Kong or by Shanghai to the rest of the world and was seized in European Union or seized in the United States. It is all well to file a local litigation in the United States or European Union to tackle the issue, but some of the client feels very disappointed that after spending a lot of attorney fees and legal costs, and they did get a very good judgment on paper, like millions of US dollar compensation. But unfortunately, this kind of judgment cannot be enforced in the People's Republic of China or the other non-familiar jurisdiction. So before taking this costly litigation, I will suggest our client to do an analysis to identify the where is the driving forces located, or where is the most easiest jurisdiction to take action. The other second common misunderstanding of our client is, okay, they said we can take action anywhere. We are big enough, we are multinational countries. As long as this identified in China, exported by India, we can take action anywhere. But they forgot to realize none of these corporations has unlimited resources. We have to focus on our resources to tackle the most difficult part of the situation. That's why forum shopping becomes necessary and extremely important when the brand owner, when they're working with their lawyer, to think about tactics to tackling infringement worldwide. I will talk about some China-specific issue because China now becomes such an important jurisdiction to the rest of the world. The majority of the products in Walmart in the United States are now manufactured in China. Even this iPad is designed by Apple California, but assembled in China. To attack the manufacturing center of the counterfeit will be an automatically consideration for a lot of brand owners in China. But China, as large as the whole United States or the whole European Union, although the codified law is just the same, it's more than 30 provinces. And I have to say it is more than 30 or 50 jurisdictions. For example, the same brand owner, if they have a similar merits of case filed in Shanghai court, they may got a totally different result from the court, from a court decision rendered by a Beijing judge or by a Shenzhen judge, which is either in the capital or southern China. We do statistics indicate that southern China judges here review the case quite quickly. For a patent litigation, like in Shenzhen, the judge can conclude the first instance within 100 days, which is quite fast. But only 150 kilometers away, which is Guangzhou court, their speed is quite slow. For example, our statistics indicate that averagely for a patent litigation, more than 300 days will be required. So if you are a plaintiff and you want to pursue infringer, better to choose Shenzhen. If you are a defendant, try to challenge the jurisdiction and put the case to Guangzhou, which will delay the whole situation. That's my some tips on the experience within China.
Thank you, Fang. I'm sure we will come back to some of the issues which you've raised. the strategic considerations that motivate the decision among various competent fora, both internationally as well as within one specific country. And these considerations are often termed or called forum shopping with a somewhat pejorative connotation, but you've in a way explained the positive aspects of forum shopping. Thank you. Now, Professor Owen Dean, I would like to also invite you to give us your perspective on the topic.
I'd like to pick up on the point of forum shopping. The concept suggests that you have a whole range of countries at your disposal and you can just choose whichever country you want to sue in. Well, it's not as simple as that, because if you want to go and sue in a particular country, that country must have jurisdiction to, the courts of that country must have jurisdiction to hear the case. Now, I'm going to tell you very briefly about under what circumstances South African courts have jurisdiction. I'm choosing South Africa for two reasons. One is it's my own country, so I'm familiar with the law and the practice. And secondly, it's pretty typical of a common law jurisdiction. So what is good for South Africa is good for many countries in the world. Now, the general proposition is that a South African court has jurisdiction to hear a matter if the unlawful act was committed in South Africa and the person committing that act was present or is present in South Africa. It's a company registered in South Africa, for instance. But what happens if those two conditions aren't met? Is it, for instance, possible to sue in a South African court against a foreign-based infringer? Now, that point arose in a very interesting and quite well-known case that we had a few years ago, which involved the hit song, "The Lion Sleeps Tonight." It is derived from a South African song, and the copyright owner decided to sue Walt Disney for using "The Lion Sleeps Tonight," being a derivative of the South African song called Mbube, without permission. Walt Disney Enterprises was a US-based corporation. It had no presence in South Africa. The unlawful act was committed in South Africa because the movie, The Lion King, which included the song, was sold in South Africa and shown in the cinemas in South Africa. But the law makes provision for someone who wants to sue a foreign-based defendant to attach or seize property belonging to that defendant in South Africa. And in this instance, Walt Disney Enterprises owned something like 250 registered trademarks in South Africa. So the copyright owner seized the 250 trademarks by way of attachment in order to found jurisdiction to sue Walt Disney Enterprises in South Africa. And the case was successful. It resulted in a very good settlement in favor of the South African party. Interestingly, I noticed from the video that was shown this morning, the educational one, the Disney-made one, that the characters were Timon the meerkat and Pumbaa the warthog. Well, in the movie The Lion King, the song, the offending song, was actually sung by Timon and Pumbaa. So Timon and Pumbaa were the bad guys in this particular movie. Now, the second problem which can arise is that the person that you want to sue is present in South Africa. It's a South African corporation, but the unlawful act was committed somewhere else in another country. Now, this was also dealt with in a case that we had recently in South Africa, the Gallo case, where a musical production was staged in South Africa, infringing, so it was claimed, various songs belonging to South African copyright owners, but the stage show also moved to other countries, the United Kingdom, Australia, and various countries in the world, and the issue arose as to whether the plaintiff could sue in South Africa for damages occurring as a result of performances in these other countries. And the court decided, no, it cannot do that. The South African court can only adjudicate upon infringements infringements taking place in South Africa. So what this all means is that if you want to use South Africa as your forum, you can sue. A foreign plaintiff can sue any time in South Africa. That is not a problem, but he can only sue in relation to an unlawful act committed in South Africa. But it doesn't matter if the defendant, the person you want to sue against, is located somewhere else in the world. And that's my opening statement.
Thank you. Thank you. Now, Professor Rochelle Dreyfus, I would invite you now to give us your perspective on the topic.
Okay, well, thank you, and thank you all for inviting me here. So I was asked to speak about a project that the American Law Institute completed, as Christian mentioned, on intellectual property and principles governing jurisdiction, choice of law, and judgments in transnational disputes. Annette Cour worked with the Max Planck Institute on a very similar project, as Christian said, and so we're splitting our time because our projects are so very similar. Both were aimed at civil, not criminal litigation, and both are in the nature of soft law. That is, they both take existing laws and propose ways for governments to adapt or interpret them to deal with the new realities of intellectual property exploitation. And I should also say we make some recommendations for change as well. And for both projects, the goals are very similar. Current litigation practice emerges from the notion that IP is purely territorial. Right, a U.S. trademark is infringed only in the United States, a Turkish trademark is infringed only in Turkey, and that's led people to assume that to stop infringement, the right holder must pursue the defendant in each state in which he has acted. However, as we know, the new reality is that infringing activities can now be transnational in scope, and we therefore need a much more efficient way to adjudicate them in order to get that infringement to stop. If worldwide actions could be streamlined, in fact, everyone would be better off. Infringements would be stopped quickly, but the defendant would also not be subject to multiple suits. If he won, he would win once. Both parties could then easily assess their business options, and worldwide litigation costs, by which I mean for both the parties and for the courts of the world, would be substantially reduced. Now, how could this be done? Well, streamlining litigation essentially raises three issues. One is the jurisdiction issues we've been talking about principally. Could we identify a single court or a small number of courts that could singly or acting together entertain a multinational suit? Second are choice of law questions. Since intellectual property law remains territorial, even if exploitation is multinational, what substantive laws would these courts apply? And then finally, the issue that Fang He brought up, enforcement questions. How do we assure that the judgment of each court would be enforceable throughout the world? So I'm going to discuss the first issue, and then Annette will pick up on the others. So jurisdiction. In other areas of law, there are places where defendants are subject to plenary jurisdiction. We would invoke those locations for litigation about intellectual property infringement as well. So which locations? First and foremost, the defendant's home, his habitual residence. For a natural person, where he's habitually found, where he maintains significant professional or personal connections. For a corporation, any state in which it has a statutory seat, where it was formed, where it's centrally administered, or has a principal place of business. Courts in the habitual residence could hear all claims arising as a result of the defendant's activities anywhere in the world. Now, as you just heard from Mr. Owen, that's a pretty controversial claim. The South African courts wouldn't support it, and neither would many other courts right now. But we typically think of people as being accountable for their actions in the place where they live. In ordinary tort cases, it's not uncommon for the defendant to be responsible at his home for harms he's caused anywhere in the world. Intellectual property is a tort, and so we think that the same should be true for intellectual property litigation. A second set of places where litigation could be consolidated are locations where the defendant has engaged in substantial activity to initiate or further infringement. In such a location, defendant could be amenable to suit on any injury resulting from those activities, no matter where they occurred. What counts as substantial activities? Things like operating a website on which infringing material is placed, maintaining broadcast facilities that facilitate infringement, or maintaining manufacturing or distribution centers for counterfeit goods. The goods may ultimately be sold around the world, but in our view, a right holder who has acted in a location, the hub of his activity, or some people think of it as a spider creating a web of activity around the world, should be stopped at the place of the spider. Habitual residence and substantial activity create the broadest basis for jurisdiction. Both of our projects also include some narrower bases, but there's not any time to bring those up. I do want to mention two other important places where you could create a place of efficient adjudication. One is based on in rem jurisdiction, allowing the assertion of authority based on the place where the goods are located. As the Turkish cases suggest, internet domains should be subject to that kind of a seizure based on where they're located. They're often located in the United States, and we do recognize that as a basis of jurisdiction. And then, of course, there's the important place of seizure of goods at a border. As the ECJ's recent Nokia case suggests, that when you get goods at a border, they're going from they might be going from one place and they might be going to a third country. There is always the question of which law should apply. And indeed, in all of the cases I talk about, there's a question of what law should apply. Permitting a court to hear a case and decide a case doesn't necessarily say that the court should also be allowed to apply its own law to the question of infringements. So on that issue and other issues, I turn it over to Annette.
Yes, Annette, please.
So I'm the last one to thank the organizers here very much to have invited me. If I may, I would like to start with a question to Professor Owen, because the sting judgment that you have been talking about is, of course, very interesting. It is about infringement, at least an alleged infringement that occurs in a lot of countries, and there was the attempt to sue the infringer in the country where it was domiciled. The South African court said this is not possible, and they relied quite strongly on a judgment that had been handed down by a UK court, the Court of Appeal, in another case. In a different case, and the South African court followed the UK appeal court. Now, this UK appeal court was, of course, then reversed by the UK Supreme Court, and I would be interested in whether that might have an impact also on the jurisprudence of the South African courts, because what is at stake here is what Rochelle has been talking about. What we have tried to do in these projects is making international litigation against infringement that occurs in multiple countries easier and more efficient. And the first step towards that goal is to be able to concentrate proceedings in one particular venue. The question then is, what is the venue? And Rochelle has been talking about that, but it's also a prerequisite that courts are ready to accept that they may be competent to adjudicate on infringements that are going on abroad. Having talked about that, then the second question is which courts are competent. We have heard the courts in the country of the domicile of the defendant are always competent. One could also ask, well, why not give competence also to the courts at the country where the plaintiff is located? Because for a plaintiff, that's of course the better solution. Having the possibility to bring the court, to bring the case always to his own judges and his own proceedings, because the plaintiff feels most comfortable there. Well, our approach was that the simple solutions and the easy solutions are not always the best solutions, but the solutions must be appropriate and must be fair. So we should really realize that this is a very sensitive point and it's not so easily solved. And the point is so sensitive also because, and now I come to the point that Rochelle has left to me to talk about, though I will be very brief. The point is so sensitive because the court that is competent to adjudicate a case will also be the court to determine the applicable law. And here again, complexities enter the scene because according to general rules, the court should apply the laws of all the countries where the infringement is occurring. In reality, however, courts prefer to apply one single law, and that is normally the law of the country where they are based. In pure counterfeit and piracy cases, the cases that we are primarily talking about here, that is not such a problem, at least not in many cases, because there is, of course, a general presumption that the laws in all the countries in the world has rules against counterfeiting and piracy. But talking about counterfeiting and piracy, as Judge Feisch has said, also is not always so easily done, because at least it must be established that the person who claims that there is counterfeiting is actually the holder of a valid right. And if we think of trademarks, it is by no means clear that the person who is infringed in one country would also be the owner of the right in another country. There may be two different legitimate trademark holders, or maybe there is simply no trademark right in the country where the manufacturing takes place, so there is logically no infringement. This needs to be taken into account. We cannot simply assume that infringement or counterfeiting in one country means counterfeiting throughout the world. So also there, rules must be devised, and the same problem is, of course, also very acute when it comes to spreading of content over the internet. Also there, of course, there is a presumption that it will be infringing in all countries, but we need to be aware that some countries may have rules that would exempt certain types of communication from liability. Again, in our project, we have to try to devise rules that make it possible for courts to deal with these complexities without neglecting the interest that may be vested by defendants and also by countries, that their separate rules, their, after all, diverse rules are respected. Now, why are we making this so complicated? Why are we devising these rules? Well, the goal seems to be clear, namely that what we all want to achieve is that judgments that are handed down by a competent court in cases that involve infringements in many countries are respected, are recognized and enforced all over the world in other countries. We heard about the problem right now between Hong Kong and China. So we want countries to enforce these judgments, and there will never be, at least that is my suggestion, there won't be an international understanding about the facilitated enforcement of foreign judgments unless there is also a common understanding of what the rules for determining jurisdiction and applicable law should be about. And this is exactly the goal of our projects. Thank you very much.
Thank you, Annette and Rochelle. In a way, that was a very eloquent plea for some harmonization in the area of certainly jurisdictional recognition of judgments, as well as choice of law rules, in order to, in a way, streamline and facilitate the difficulties or reduce the difficulties and complexities of managing international litigation. But there has already been a question directed to Owen Dean. Perhaps you want to take it, and Judge Feisch might want to chime in. Perhaps, Professor Dean.
Rephrase the question for me slightly.
The question didn't come from me. The question came from Annette. She was referring to the case example which you gave, where you said that in order for a South African court to exercise jurisdiction even over a defendant based in South Africa, there would also have to be infringement in South Africa. And Annette was questioning whether that might be in line with the English leading case, where actually that latter requirement was not, if I understood correctly, was not also.
Well, the way the court in South Africa approached the question was to say that in this case it was copyright. Copyright rights are territorial. although there is a large measure of conformity in various countries' copyright laws, there are differences as well. Certain countries make exemptions, for instance, for private study or quotations and such like. Other countries don't do that. So it's theoretically possible that something could be a copyright infringement in one country and not a copyright infringement in another country. Now, the problem, as the court saw it, was that it would have to make pronouncements on foreign law. The way the plaintiff pleaded the case was to say, in South Africa you infringed the South African Copyright Act, in the UK you infringed the UK Copyright Act, in Australia you infringed the Australian Copyright Act, and so forth. Now the court said, we don't consider ourselves to be particularly well versed to go and express a view as to whether something infringes copyright in Australia. We would have to get expert evidence to come and tell us what the Australian copyright law says and what its finer nuances are and that sort of thing. And the court then said, and perhaps this was one of the most important issues, there are policy considerations which judges take into account when giving judgments in their own country. Now, we as South African court may see a cold, hard case on the facts, but we're not aware of the policy considerations which apply in a particular country. Therefore, we are entering into very dangerous ground. We are skating on thin ice if we presume to ourselves the ability to make findings of law based on foreign countries' law. And on that basis, the court said, no, we can only judge on the South African infringement, and if you want to claim damages in the UK or Australia or wherever else, you must go to the courts of those countries.
Thank you. So that basically means that a court can only apply its national intellectual property law, and consolidation of infringement or counterfeiting cases internationally would not be possible.
If we had a worldwide intellectual property law, it would be a different matter. But because intellectual property rights are territorial, it's considered, what was considered by the South African court, not to be desirable. Now, that was a copyright case. Imagine a trademark case where certain marks may mean something, may have particular meanings in certain countries and different meanings in other countries. Now, it's conceivably possible that two marks could be confusingly similar in South Africa, but they may not be confusingly similar in Turkey, for instance, because there are different mental pictures conjured up by the trademarks, the pronunciation might be different, and all of that sort of thing. So how does a South African court make a judgment as to whether the average man in the street in Turkey is going to be confused by two trademarks?
Let's hear from the judge from Turkey. Judge Zhang, please.
Ben de yargıç olarak yargıç olarak Sayın D'nin beyanına katılıyorum, görüşüne. Zira hakimler pozitif hukuka göre karar verir. Yani o ülkede yürürlükte olan hukuka göre verir. İdeal hukuk olabilir ama o düşündüğünü değil, mevcut yasalara göre vermek zorunda. Bizde Türkiye'de milletler arası özel hukuk kanunumuza göre yabancı bir ülkede bir karar verilmişse ve o uyuşmazlık o ülkenin bir mahkeme kendi ülkesinde işlenmeyen bir suçla ilgili veya bir tecavüzle ilgili bir karar vermişse bu tür kararlar tanınmıyor. Dolayısıyla da başka ülkede tanınmayan bir karar, bir konuda karar vermenin de pratik bir anlamı olmayacaktır. Ülkesellik prensibi nedeniyle sadece Türkiye'de işlenen fiiller Türk yasalarına göre uygulanabilir. Türkiye dışında işlenen fiil Türk yasalarına göre suç olmadığı için onun nasıl yargılama koşulları da zaten işlendiği ülke hükümlerine tabi. Dolayısıyla bence burada başka bir ülkede işlenen bir fiille ilgili diğer bir yargıcın karar vermesi en azından delillerin toplanması açısından da çok olanaklı değil.
Thank you for your statement, in a way reinforcing Professor Dean's position. I would now invite also to Judge Feisch to comment on this, but would also invite you now to get ready with any questions and comments you have, because I would turn to you now after I've heard from Judge Feisch.
First of all, I want to say that we're dealing only with civil, not criminal matters. Well, at least I am anyway. Secondly, I think that we have to say this, that judges acting within the EU, and perhaps Annette can say something about this, look with EU and European Economic Community area spectacles on, if I may put it like that. And almost all our decided cases, if we're to look to decided cases, have been decided within the European or the EU context. Now, that said, this very point came up in the Octavis case, and I know we have little time, but I will do no better than it was a factor that was argued that there may be different considerations in different countries on the same topic, for in this case infringement. This is what one of our patent judges said. As to the different national approaches, I accept that there are differences. In my view, however, the differences are rather less now than they have been in the past. Certainly in recent years, the European patent judiciary have been striving for consistency. And let me put in a point here that the European Patent Office has been running, as some of you know, European patent courses for judges and for practitioners now for 15 or more years to try and get this uniformity. I continue. I am skeptical that the remaining differences approach as opposed to other factors are responsible for different outcomes in parallel cases, which of course is one of the sins which we try and avoid. In any event, it seems to me to be manifest that it will reduce the likelihood of inconsistent decisions if one court at first instance and one court on appeal determine all 5 of Octavis's claims, and they were in France, Germany, they're all in EU countries. So, yes, there may be differences, but it seems at any rate, on interlocutory basis, the courts tend to, I don't know, take a rather liberal view of the matter.
Thank you. Reinforcing the case for efficiency as well as lack of, or rather avoiding lack of consistency or inconsistency. I see that Annette wants to say something. I see that Owen Dean wants to say something. But I would first want to also invite the audience now to indicate any questions which you may have right away. Well, yes, please. There is a question. The gentleman in the middle.
Thank you very much. I'm very impressed by the panelists. Actually, I would like just to hear their comments on, for international litigation, fine, everything, but as plaintiffs, I know that the remedy for plaintiff is not only to win the case. There is a second element of execution. If I'm a plaintiff, I want to realize my compensation. So the order of the court itself that I have won the case is not enough. I want to execute the order so that I get the money. And unfortunately, with the international litigations, especially counterfeiters of or infringers of IP, they can be prosecuted at one jurisdiction where all the assets are not there, all the money are not there. So I cannot attach their property because, you know, the claim usually for IP will be huge of money. So if at all the money are located in other areas, and if it becomes too expensive for me to execute that, and then what is your comment? Because it appears like I'm using my rights have been infringed. The order has been sold. I have paid a lot of money to lawyers. I start paying a lot of money to chase properties in other countries. Thank you.
Thank you. That's a very practical question. How do you enforce a judgment against an infringer who may be based somewhere else, or against assets which may be based somewhere else, so that you can actually monetize the judgment which you made? Owen Dean, I think.
I mentioned the example of the Lion Sleeps Tonight case, where Walt Disney was based in America, sued in South Africa, and the South African court acquired jurisdiction by attaching Disney's trademarks. Now, the purpose of attaching the trademarks is to have an asset in the jurisdiction of the court against which you can execute the judgment. Say, for instance, the court had awarded damages of $1 million against Disney. If there was no attachment, it would be very difficult for the plaintiff to execute that order against Disney in America. But because of the attachment of the trademarks, theoretically what could have happened is that the plaintiff could have caused the trademarks to be sold off in order to realize $1 million for the purposes of the damages claim. If the defendant has no assets at all, a local defendant for that matter, it becomes very difficult to get execution of your judgment. That's one of the risks you take with litigation, and it's one of the things you have to weigh up whether it's worthwhile going over to litigation. But more often than not, in my experience, as in IP litigation, the first prize is to get the injunction or the interdict to stop the infringement being perpetuated. And that, of course, doesn't depend on payment of money.
Rochelle?
Yes, I think that the question actually illustrates exactly why our projects are going forward. I think true retail justice in which everybody pursues their action locally is a thing of the past, because infringement itself is all over the world, assets are all over the world. Yes, sometimes you can get an injunction, but if the defendant is no longer operating from the place where you've received the injunction, you've got the same problem again. And so I think that much as retail justice might be wonderful, we really need to think of a more global approach. And I think your case brings that up absolutely perfectly. I mean, on seizing the trademarks, it wouldn't work in the United States. Trademarks are not rights and gross. You can't sell Disney's trademarks and then use them. They're not available to you. So I think we do have to start thinking about new ways of doing this.
I now have Annette Fang and Judge Feisch. Annette.
Yeah, I tried to pursue this case a little bit further. Of course, I realize that judges all over the world are very reluctant to accept that they may be competent to adjudicate on infringements that is going on in other countries. But again, at least in our projects, and increasingly also in court decisions like the decision by the UK Supreme Court that came after the Sting judgment, also courts realize that they may have this power and that they should really, in order to help those who are pursuing infringements that are going on in several countries, that they can exercise this power. I want to rephrase the question a little bit, and I want to talk about a case that probably everybody knows here in the room. It's the case about the Pirate Bay in Sweden. Those who were offering infringing content on the internet, they were sued in criminal proceedings in Sweden. They were sentenced to jail, but as adjacent or in adhesion to that criminal court proceedings, there were also civil proceedings, and there were also sentenced, or there were also damage claims for the infringements by downloading, by distributing the contents that had been occurring worldwide. So what did the Swedish court do? They also gave a sentence about the damages, the civil damages that had occurred all over the world. Now, with the approach that has been echoed in your interventions, that judges can only adjudicate on infringement that occur in their own country, this might not have happened. So this efficient way of having a junction of criminal prosecution plus damages that have occurred as a result of the infringement worldwide would not be possible. And I ask myself whether, at least in those cases, you would accept that there is a possibility for the courts to look into these matters, even though it goes beyond their own territory.
To legal practitioner, there was two types of IP litigation from actual perspective. One is to have a case as strong deterrent effect as possible. In our old Chinese saying, we kill a chicken before a monkey and to try to frighten the monkey. So no matter how many resources used to do action against this defendant, whether the defendant has asset or not, we will pursue this kind of action. This action, litigation might be a good precedent to other jurisdictions. This is one type of case. The gentleman's question will be probably the other side, another type of litigation, which is the brand owner want to collect as much money as possible, or collect as much compensation as possible. In such situation, we usually advise our client to seek whether the interim measures is possible in that jurisdiction to freeze their bank account or freeze their asset before the action was launched. Of course, proper investigation of the asset or proper due diligence will be required before launch the action. But it would be much better to then go in order to proceeding and obtain success on paper.
We're coming to the end of our time. Any burning question from the audience? Otherwise, I would just invite Judge Feisch also to make.
I'll be very brief. We must get it clear that we're talking about two things here. We're talking about the enforcement of orders of the court relating to injunctions, delivery up, destruction, all this kind of thing on the one hand. And your question, sir, was to do with what we call money. Now, that is a different matter. Two, in general, you find in practice with intellectual property that once a plaintiff or claimant has got what they want by way of injunction, and that in common law jurisdiction can include an injunction against the director of the company in personam, so you've got two judgments, they usually settle the thing then and there or leave it, even though they may forego costs. If they're satisfied the injunction will stick, you've got in IP terms 9/10 of what you want. If you want money as well, that's a different matter. If you win the case and you go for an inquiry as to damages, you've got another action on your hands, and 99% of cases never do that. If you want to collect money from somebody somewhere else, then I'm afraid you've got to look at, except in the EU, where we have special arrangements, but elsewhere you have to look on whether your country has got a specific reciprocal judgment enforcement act relating to money claims. Sorry, that's the best we can do.
Thank you. Legal advice. Thank you. I see that there is one more question. I think we can take it since we started a bit late.
Sorry, I would like to seek for clarification from Professor Dean concerning the issue of the private international law, especially the conflict of law rules. When you are talking about jurisdiction in South Africa, my own understanding of the rule in our country, which is a common law country, is that a court in a territory we have jurisdiction if you can find the company. That means if you can serve the company. So which means it's the service that determines the jurisdiction, the service to serve the tortfeasor. And after the jurisdiction, the classification will be done. Then the issue will be classified. Is it tort? Is it contract? So once it is classified as a tort, I believe the connecting factor will be the next thing for the judge to find, which will connect to the lex causa, which is the applicable law. But the way you explained the South Africa system to us, it appears as if both the jurisdiction and the choice of law are lumped together. Why I said that is that, if I understand you correctly, you said that in South Africa, for a judge to have jurisdiction, it will, they will find out whether that tort occurred in South Africa. I believe when the stage to find out about where the tort occurs is when you are looking at the choice of law rules, not the judicial stage. I don't know, I would like to get that clarification so that I'll be able to understand the system better. I believe the conflict rules differ from one country to another, but I want to know the South Africa rules, whether they are lumped together, the judicial and the choice of law rules, or whether they are treated differently.
Thank you. Professor Dean.
I think you must view intellectual property laws and intellectual property litigation as being separate from the general body of law. There are rules of conflict of laws on a private law basis, which is one thing. As far as intellectual property is concerned, the starting point is that the rights are territorial. You may have registered your trademark in South Africa. You may not have registered it in Australia. Therefore, you have no protection in Australia. So you can't go and try and enforce a right in Australia when no right exists. That's why we talk about trademark or intellectual property laws as being territorial. Now, the effect is really to lump jurisdiction and choice of laws together, because if you're saying to the South African court, we want you to make a damages award for unauthorized productions of a stage show in Australia, the first question you have to ask is it unlawful in Australia? Do you have any rights in Australia? And that is dependent on whether your intellectual property enjoys protection in Australia. The next question is, is the South African court qualified to exercise a judgment on Australian law? It can't judge the case on South African law because it's not a South African right that you're dealing with. It's an Australian right. So the court has to ask itself, are we competent to give a ruling on Australian law? And the approach of the South African court has been to say no. But the result is that the choice of law and the jurisdiction issues fall together. Don't understand me to be saying that I don't think that the courts ought not to be able to exercise extraterritorial rights. I think in the overall scheme of things, it would be very desirable if that were to be the case. And I think the studies that are being conducted are very, very useful exercises, and hopefully they will produce some system at the end of the day which will make it possible to sue for infringements committed extraterritorially. But what I'm saying is at the moment, with laws being so different and circumstances being different, the courts are not willing to do that at this point. Judge Feisch mentioned the issue of Europe, and that the European courts are taking a more robust attitude. That's all well and good because you have European directives which standardize the laws. There are big differences between laws in South Africa, for instance, and laws probably in Turkey. I would think there are major differences between the laws. So as long as there is no standardization of laws, I'm afraid we're going to have to live with the present system.
That would be actually a very interesting point for discussion, but I'm afraid we cannot really continue anymore because we've run out of time. In a way, we've seen almost a sliding scale between proponents of internationalization of jurisdictional issues, the possibility of streamlining jurisdiction and consolidating jurisdiction in one court that is then competent to apply all applicable laws and deal with all infringements worldwide, of course, provided that there has been infringement in those specific countries because rights subsist in those countries. And in a way, you giving you, Professor Dean, giving the position of the South African court, which basically says, no, we are not competent because we cannot apply in a competent way the laws of any other countries. I can only say both are very, very almost symbolic positions, very positions which you find everywhere in the world, the position where the court basically only applies its own IP law, and now the position increasingly that militates in favor of trying to streamline, follow globalization also in the jurisdictional aspect. I'm sorry that we cannot continue anymore. I hope that you found the discussion interesting. I realized that we at maximum were able to scratch the surface. I know that most panelists will still be around here and will be happy, saying for them, happy to discuss the matter further with you. And I now hand over back the floor to our Master of Ceremonies to tell us what the next steps are. Thank you again.